I direct my deputies to call the distinguished members of the jury so we may formally start our session.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم قل أعوذ برب الناس ملك الناس إله الناس من شر الوسواس الخناس الذي يوسوس في صدور الناس من الجنة والناس صدق الله العظيم.
Assalamu alaikum. Today's session has been convened for special business, which is to discuss and debate upon the resolution whether the Parliament is the supreme body in the constitutional scheme of Pakistan. I welcome the honorable mentors Mr. Sahibzada Uzair Hashim, Dr. Yasir Aman Khan, Muhammad Suhaib Sheikh, and Mr. Ali Ahmed Shah. I welcome the distinguished ladies and gentlemen of the jury and the honorable speakers who will participate in the debate. The debate will be conducted in two sessions. Debate rules along with the time slot have already been shared with the distinguished debaters. Just to reiterate, each session shall have two groups of honorable debaters who will respectively speak in favor and against the resolution. The debate will be initiated by the group of debaters in favor of the resolution. The speaker from the affirmative team shall have 6 to 7 minutes for his or her opening statement. Then the group opposing the resolution shall have the right to make its opening statement for 6 to 7 minutes. Afterwards, both the groups shall have 3 rounds of approximately 4 minutes, each to make claims, counterclaims, raise objections, and respond to them. I will remind you about the time gently, and I expect the honorable members of the House to keep order and observe the decorum of the House. Our first session has Group A, affirmative team, which has been mentored by Honorable Mr. Sahibzada Uzair Hashim, and the debaters are Ayman Naveed, Huda Binte Haider, Irsa Kamran, Nurul Huda, Rija Maryam, and Pakiza Ilyas. Group A shall favor the resolution. Opposing team, which is Group B, has been mentored by Honorable Dr. Yasir Aman Khan, and the debaters are Hashim Shams, Ali Hasnain, Raja Umar Ali, Awais Tanveer, Raja Abdul Ahad, and Numan Shiraz. Group B shall oppose the resolution. Our distinguished members of the jury shall mark the performance of the debaters and groups in accordance with the assessment rubric handed out to them, which has been shared with all the members of the House. I direct the members of the jury to strictly comply with the jury instructions that have been passed to you and to remain unbiased. Now I invite the designated debater from Group A to come to the rostrum and present his or her arguments in support of resolution.
Honorable Ma'am, Right Honorable teachers, respected jury, and dear members. The debate surrounding the supremacy of the Constitution is an ongoing and important topic in the Pakistan's legal and political discourse. It revolves around the question of supreme body in the constitutional scheme of Pakistan. Pakistan's constitution was first created in 1956 by the Constituent Assembly with the subsequent variants in 1962 and 1973. Pakistan's constitution serves as the fundamental legal document that establishes the country's legal framework and political framework. It establishes the fundamental rights, and along with fundamental rights, it creates the independence of judiciary. Here, I would like to highlight the difference between the Constituent Assembly and the Parliament. The Parliament is the creation of Constitution. It is created by the Constitution, whereas a Constituent Assembly is created for the sole purpose of enacting and drafting the Constitution. It has only purpose to draft the Constitution. The Constitution of 1973 was drafted by the Constituent Assembly. This debate takes on added significance when it is examined in the light of preamble. The preamble of Pakistan emphasizes several key principles, including the principles of parliamentary democracy, separation of power, independence of judiciary, and fundamental rights. That Constitution is the supreme law of the land. Based on these principles, the preamble reinforces the notion that the Constitution should be the supreme law of the land. We contend that it reflects the will of people of Pakistan, and it provides a mandate for the Constitution's authority over all the institutions, all the sources of power in the state. Let's take this debate into a global perspective. The oldest democracy in the world, USA, it has the supremacy of Constitution because it has a written Constitution. And along with this written Constitution, Article 6 under Clause 2 says that the Constitution is supreme law of the land. It further says that federal laws and all the treaties must be in accordance with the Constitution. Some people argue and compare the Parliament of Pakistan with the Parliament of UK. Indeed, the UK has parliamentary supremacy. The Parliament of UK plays an important role in the domestic laws, but it does not possess any legal constitutional document. In contrast to the UK, Pakistan has a written constitution which clearly emphasizes the demarcation of powers. Along with demarcation of powers, our constitution does not give the parliament absolute authority to do whatever it wants to do. It has to work within the limits prescribed by the constitution. It has to work in accordance with the constitution. We have many case laws related to this topic. I can name many case laws, but I would like to highlight an important one. Two are most important, that Asma Jilani case and Fauji Foundation versus Shamimur Rahman case. In this context, it had been held that the constitution is supreme. The Parliament, Majlis-e-Shura, provincial legislature has to work within the sphere assigned by the constitution. They have to enact law within the limits prescribed by the constitution. No governmental action, no law enacted by the legislature can bypass the constitution. Law is the command of sovereign, backed by sanction. So what is law in Pakistan? No doubt the constitution is the law of the land of Pakistan. But this brings us to our second question, that who are sovereign? It is you who are sovereign. It is the people of Pakistan who are sovereign. The question still remains the sanction. The sanction is the Article 6. Let me draw your attention to the Article 6 of the Constitution, which says that anyone who abrogates the law, goes against the Constitution, shall be found guilty of high treason. So Constitution is not just a mere document, a mere legal document. It is the fundamental legal document that is protected by the sovereignty of people and the sanction of Article 6. Along with all this, the judiciary has an important role in upholding the supremacy of Constitution, because the Constitution gives the judicature the right to keep a check and balance on the powers of the legislature. The Constitution gives it the right of judicial review, so it can strike down any laws which goes against the provisions of the Constitution. The judicature has an important role in Pakistan, and it has been enshrined in the preamble of Pakistan as an independence of the judicature. Moving on in our argument, along with all this, you must have heard the term constitutionalism. The term constitutionalism is used for the supremacy of the Constitution. There is no such term as the parliamentarianism, because there is no supremacy of Parliament. The Parliament has to work within the limits prescribed by the Constitution. That's why the constitutionalism is an international term used for the supremacy of Constitution. Parliament, being the product of Constitution, has to work within these parameters set by the Constitution. All the governmental actions, all the actions of all the organs of the state must be in accordance with the Constitution. To wrap all the argument, I would like to say that having holistic view of the entire Constitution, read with the preamble, let it be realized that the Constitution is supreme law of the land. Thank you.
I strongly believe that Parliament is supreme, as Constitution itself proclaims that there is no limitation on the power of Parliament. Article 239, Clause 5 and Clause 6 state, no amendment of the Constitution shall be called in question in any court on any ground. Clause 6, for the removal of doubt, it is hereby declared that there is no limitation of power of Parliament, and it can amend any of the provision of the Constitution. As the clauses explain that Majlis-e-Shura can amend Constitution, then how Constitution be supreme?
First, I would like to address the point that is raised by the affirmative team, amendment in Constitution. Parliament can amend the Constitution, but it's not the absolute power. Parliament cannot go beyond the procedure which is provided in the Constitution. You cannot remove the salient features, including the Islamic State. You cannot change it into the secular. You cannot remove Islamic provisions. You cannot remove fundamental rights. You cannot remove parliamentary democracy. You cannot remove federation. You cannot remove independence of judiciary. Moving on, I intend to argue in favor of constitutional supremacy by asserting that the Constitution stands as the ultimate law of the land, surpassing the authority of any individual or institution. It is crucial to recognize that the Parliament operates within the boundaries set by the Constitution. Part 3, Chapter 2 of the Constitution specifically outlines the structure, including its composition, duration, and meetings, as evident in Article 50, 52.
Constitution, the judicature is an independent entity that is tasked with upholding the rule of law and preserving the constitutional supremacy in the country. If a law is found to be inconsistent with the Constitution, the judicature has its jurisdiction to declare it void. The preamble of the Constitution provides that wherein the independence of the judicature shall be fully secured. Supreme Court enjoys the jurisdiction of judicial review against the administrative actions of the legislative. The Supreme Court and the High Court of Pakistan enjoys the jurisdiction of judicial review under the Article 184(3) and Article 199 of the Constitution. Moreover, in Article 188 of the Constitution, the Supreme Court has the jurisdiction to review its judgment as well as made by the Parliament. Kindly tell us, if the Parliament is supreme, then why the laws which are inconsistent with the Constitution are struck down by the judicature?
I have a question from opponent team कि कॉन्स्टिट्यूशन में ये कहाँ लिखा है कि कॉन्स्टिट्यूशन है वो कॉन्स्टिट्यूएंट असेंबली ने बनाया?
My question is, should not the Parliament have the power to address emerging issues if the constitutions become outdated?
That the Constitution of Pakistan is supreme. The Constitution lays down fundamental principle, limitation on the power of the Parliament. It represents the scope of legislative power, outline the fundamental rights that cannot be violated by the Parliament. It establishes checks and balances to prevent abuse of power. For example, according to the Article 50 of the Constitution, the Parliament of Pakistan is bicameral. Similarly, under Article 52, the term of National Assembly is continued for five years. Under Article 58, states deal with the dissolution of the National Assembly. Clause 2 of the Article 224 states when a National Assembly or a Provincial Assembly is dissolved, the election will be held within 90 days. Tell me how the Parliament is supreme. Even all the procedure, all the structure to run the state and the Parliament are governed by the Constitution itself.
Pakistan is a democratic state where all the branches of government like Parliament, Executive, the Judicature and public institution works in accordance with the Constitution. It is the Constitution which tells us that Pakistan is a parliamentary form of government and no dictator or any other powerful group or individual is allowed to violate the Constitution. Basic principles of democracy includes that it protects fundamental rights, it has a separation of power, and most importantly, it has a legislature to make law. The preamble of our Constitution states clearly for the preservation of democracy, and the founder of Pakistan, Quaid-e-Azam Muhammad Ali Jinnah, said that Pakistan would be a democratic state based on the Islamic principle of social justice. So coming to the point, what is democracy? Democracy is the will of the people and right to choose their representative through vote. People transfer their power to the government and all the branches of government, either legislature, executive or judicature, works in accordance with the Constitution and exercise its power in accordance with the Constitution. So if there is no Constitution, so what will be happen? There will be a dictatorship, monarchy or a kingship. So where there is a Constitution, only the parliamentary democracy developed there and rights of citizens are protected because the Constitution is the supreme law of the land. To conclude, Parliament exists only in democratic form of government and this democracy is protected by the Constitution, which is the supreme law of the land. So today, debate brings an important responsibility which relies in your hands. Through your votes, you will be standing either with supremacy of Constitution or against the supremacy of the Constitution. Thank you so very much.
Separation of power is adopted in Constitution of Pakistan. Parliament has power to legislate in any matter. No other institution can intervene in its power. Quaid-e-Azam said, the Constitution of Pakistan has yet to be framed by the Pakistan Constituent Assembly. I don't know what the ultimate shape of this constitution is going to be, but I am sure that it will be of democratic type, embodying Islamic principle. Islam and its idealism have taught us democracy. It has taught equality of men, justice and fair play to everybody. There is a case law, Federation of Pakistan versus Mia Muhammad Nawaz Sharif. PLD 1993, Supreme Court 473. In this case, the Supreme Court reaffirmed the principle of parliamentary supremacy and held that the Constitution was a living document that could be amended by the Parliament. The court also held that the Parliament had the power to amend the Constitution's basic structure and that there were no limit to the Parliament power to amend to the Constitution.
Welcome back. The second session is hereby called in order. Now we will formally start the debate. Our first session has a formative team which has been mentored by Honorable Mr. Ali Ahmed Shah, and the debaters are Sayyid Abdul Fattah, Ghafoor Kazmi, Muhammad Sami Nasir, Ali Abdullah, Sheikh Moinuddin and Nurul Subha. Affirmative team shall speak in favor of the resolution. Group D has been mentored by Honorable Mr. Muhammad Suhaib, and the debaters are Hina Batul, Laiba Iman, Aisha Anis, Zara Kaleem, Muqaddas Gul and Rimsha Bibi. Group D shall oppose the resolution. Our distinguished members of the jury shall mark the performance of the debaters and groups in accordance with the performer handed out to them, which has been shared with all the members of the House. I direct the members of the jury to strictly comply with the jury instructions that have been passed to you. The second session is hereby called in order. I think the team members of Group C and D all are sitting here. Our distinguished members of the jury shall mark the performance of the debaters and groups in accordance with the performer handed out to them, which has been shared with all the members of the House. I direct the members of the jury to strictly comply with the jury instructions that have been passed to you and to remain unbiased. I invite the designated debater from Group C to come to the rostrum and present his arguments in support of resolution. You have 6 to 7 minutes for that.
Ladies and gentlemen of the jury, I stand here before you with the honor to set in motion this debate on the supremacy of Parliament. Madam Speaker, we as a nation have tried our best to ignore this debate, to let this difficult question pass, to switch the lights off on this issue and to not let the elephant in this room. But there is a time and season for everything. Madam Speaker, I say, feel and believe that after having 7 parliaments dissolved in a span of 75 years of independence, and after having at least 12 prime ministers duly elected by the parliament removed through unconstitutional or quote-unquote the supra-constitutional means, the time has dawned upon us. The season has arrived and the moment has reached when we enter the room and grapple with this elephant sitting in the room right here in front of us. Madam Speaker, the rules of this debate compel me to stay true and loyal to the question framed for us and confine myself to the existing constitutional scheme of Pakistan. However, this will not stop me of stating obvious, that is, what the question of supremacy of parliament is too big and too important, a question to be decided merely by arguing over the interpretations of few constitutional provisions. I know and share the well-fondness of ours, the lawyer folks, for the questions of interpretation. However, it would be injustice if I do not refer to, and that's all I'll do for it. If we agree, and certainly our Constitution does in very first few lines of the preamble, that the authority in the state is to be exercised by the people of Pakistan, by the people of Pakistan, then there remains no debate, no question, and no fight that Parliament is directly elected by the people, which is the supreme body of Pakistan. This is true as a matter of constitution, and this is true as a matter of political science. Madam Speaker, I know that there are few constitutionalists sitting in the room that will argue that will brush away any argument that goes political. But I would not stop at the first para, and I go on the second and third para of the preamble of Constitution, which says that where in the state shall exercise its powers and authority through the chosen representatives of the people, through the chosen representatives of the people. Madam Speaker, may I need to say more? The last time I checked, that Parliament is the only institution being elected by the people of Pakistan. Madam Speaker, although I cannot hear the murmurs promoting in the room, but what the Constitution that we agreed upon, oh, have you agreed that Justice Jawad Khwaja's additional note in the case of disqualification of ex-Prime Minister of Pakistan, Mr. Yusuf Raza Gilani, where he said, we need not to muddy our waters with the ancient concepts of parliamentary sovereignty and stick to the Constitution that we agreed upon. Madam Speaker, for those trying to murmur, I would say this: yes, what the Constitution that has been created by the Parliament, in what fanciful, absurd and dystopian world the Creator gets bound by the creation? After this, it reminds me of one such constitutionalist, the Saturn himself, who says, "Khalaqtani min naryun wa khalaqtahu min teen." Oh God, you have set the rule that fire is superior than the sand. Yes, indeed. And what makes you think that God has no authority to change its rule? Yes, the Constitution, being the creation of Parliament, can be amended by the Parliament. Madam Speaker, as a transporter of supremacy of Parliament, I feel no shaking in my legs, and I firmly stamp and say that Parliament is not bound by any limitation to amend the Constitution. And Article 239(6) of the Constitution be my witness. For the removal of doubt, it is hereby declared that there is no limitation whatever on the power of Parliament, Majlis-e-Shura, to amend any of the provisions of the Constitution. No limitation whatever on the power of Parliament.
Madam Speaker, how I wish to keep going on, but having opened the debate, I cede the floor for the other side of this debate, for I and my fellows would love to hear what they have to say at their hand in this debate. Thank you, Madam Speaker.
Assalamu alaikum. My name is Hina. I am joined by my fellow debaters Laiba Iman, Aisha Anis, Zara Kaleem, Rimsha and Muqaddas. Today we are diving into the topic, the supremacy of the Constitution. Constitution is the supreme law of the land that all other laws, government and government actions must be in accordance with it. Pakistan has a hybrid legal system with a combination of elements of both Islamic laws and common laws. In Pakistan hybrid legal system, the constitution is considered the supreme law of the land. For example, Islamic law is the important source of legal guidance in Pakistan. It can override the provisions of the constitution. The constitution is often referred as the ground norm. The supremacy of the constitution is evident in historical documents like the Objective Resolution of Pakistan, 1949. It emphasized the supremacy of Allah and the importance of Islamic principles, while also recognizing democratic ideals and human rights. One of the landmark judgments delivered by Justice Jalani was in the case of Al-Jihad Trust versus Federation, 1996. The Constitution is the supreme law of the land, and all other laws, including the martial law regulations, are subject to its provisions. Moreover, Constitution Assembly made the Constitution instead of the Parliament. After the political turmoil of 1971, there left a need of Pakistan to make a Constituent Assembly of 25 members, including 6 from opposition under the chairmanship of Mahmood Ali, who was later on replaced by Abdul Hafiz Pirzada, and drafted the Constitution of 1973. If we look back in the history of Constitution of Pakistan 1956 and 1962, they were also made by the Constituent Assemblies. Furthermore, Constitution of Pakistan gives us the concept of separation of power, the executive, the legislative and the judicial branch of the government. The executive branch is responsible for the implementation of laws and policies. Moreover, the legislative branch is enact the laws, while the judiciary is to interpret the laws. This separation of power ensures that no single branch of the government can become too powerful. The Constitution of Pakistan vests ultimate authority in the Constitution itself. This means that no branch of the government can override the provisions of Constitution. The supremacy of the Constitution in Pakistan are essential to ensure that government operates within the rule of law, that the rights and freedom of citizens are protected. Now I want to invite Zara to present remaining claims. Thank you.
The claim presenting is that Parliament derives its authority through the Constitution. Without a Constitution, Parliament would lack the legitimacy and authority to act on the behalf of the people. The Constitution provides legal and political safeguards against abuses of power by the Parliament. There are a number of examples which shows that the authority of Parliament is derived from the Constitution. In the United States, the Supreme Court has the power to strike down laws passed by Congress. They are found to be unconstitutional. Similarly, in India, the Supreme Court has the power of judicial review, which allow it to declare laws passed by the Parliament as unconstitutional if they violate the provision of the Constitution. The Constitution is the supreme law of the land, and it establishes the legislative authority of the Parliament. In addition, Parliament can amend the Constitution but it cannot change the basic structure of the Constitution. The basic structure of a Constitution comprises certain fundamental and essential features that form the backbone of the Constitution and shape its identity. Parliament can amend the Constitution, but only within the limits prescribed by the Constitution. The Constitution is the supreme law of the land, and any attempt to violate its provision or alter its fundamental features would be unconstitutional and invalid. In practical terms, this means that Parliament can amend the Constitution to make change to the legal framework of the country. It cannot alter or amend the foundational principle of the Constitution. Moreover, in most democratic countries, including the United States, the Constitution provides for an independent judiciary that has the power to review and strike down any laws or action taken by the government that are found in the violation of the Constitution. This is an important principle of separation of powers. It ensures that no single branch of government has unchecked power, and the Constitution serves as the supreme law of the land. The independence of the judiciary is essential for the protection of fundamental rights and the rule of law. Thank you so much.
All empowering, this grand basic structure theory, which is nothing but, forgive me for saying this, mood swings of the judges who would sit at night, contemplate and look in the stars and decide, oh, our Constitution has a basic structure and we cannot be done away. Although Constitution says in Article 239, Clause 5, no amendment of the Constitution shall be called in question in any court on any ground whatsoever. Still, our Supreme Court has made up, or dare I say, borrowed this doctrine of basic structure from India to actually rewrite the Constitution and undermine the Parliament. If my fellow is worried about the safety and preservation of the sanctity of the Constitution, I would ask, are we safer in the hand of the Parliament who has stood the test of time, or are we safer in the hand of the Supreme Court who, after being given several chances, has always conveniently found martial laws not to be against the basic structure of our Constitution? Madam Speaker, why give these potent and all-powerful tools in the hand of unelected judges? Even if there is basic structure to our Constitution, the Parliament is a far better and far superior place to define, declare and protect our Constitution.
My competitor party claimed that Parliament can amend the Constitution, but it cannot amend the basic structure of the Constitution. Yes, Parliament can amend the Constitution, but it cannot change the basic structure of the Constitution. The basic structure of the Constitution comprises certain fundamental features and essential features that form the backbone of the Constitution and shape its identity. For example, sovereignty to Allah Almighty, fundamental rights, and independent judiciary. Parliament cannot change these features. Next, these features are so integral and essential to the Constitution that any attempt or alter or amend them would fundamentally change the character and identity of the Constitution. And according to Article 239 of the Constitution, Constitutional Amendment Bill, a bill to amend the Constitution may originate in either houses, and when the bill has been passed by the votes of not less than 2/3 of the total membership of the houses, it shall be transmitted to the other house. My competitor party claimed that Parliament is sovereign. Then why, if Parliament is sovereign, then why Parliament needs the 2/3 majority of the two houses? The doctrine of basic structure is a legal principle that has been recognized and applied by courts in many countries around the world. The origins of the doctrine can be traced back to the landmark case of Kesanmanda Bharti versus State of Kerala 1973 in India, where the Supreme Court held that the Constitution of India has a basic structure that cannot be altered by constitutional amendments. The doctrine of the basic structure holds that there is a basic structure to the Indian Constitution and Parliament of India cannot amend the basic structure. Parliament can amend the Constitution but only within the limits prescribed by the Constitution itself. The Constitution is supreme law of the land, and any attempt to violate its provisions or alter its fundamental features would be unconstitutional and invalid. Process of amendment. The constitutional process of Pakistan allows for amendments to be made through a two-thirds majority vote in both houses of parliament. However, the Supreme Court of Pakistan has held that Parliament's power to amend the Constitution is not absolute. In Article 239 of the Constitution of Pakistan 1973, it specifies that two-thirds majority of both houses parliament is compulsory for the amendment of Constitution. One of the most prominent jurists in Pakistan is Justice Tasadduq Hussain Jilani, who served as the Chief Justice of Pakistan from 2013 to 2014. In a 2015 lecture at the Lahore University of Management Sciences, Justice Jilani discussed the doctrine of basic structure and its application in Pakistan. He emphasized that the doctrine serves to protect the fundamental principles of the Constitution and ensure that they cannot be altered or abrogated by the legislature. The concept of supremacy of Constitution holds that the highest legal status and serve as a framework which the power of Parliament exercised. In the case of Asma Jilani versus Government of the Punjab 1972, the Supreme Court of Pakistan held that the fundamental rights provisions of the Constitution are part of the basic structure and cannot be amended in a manner that takes away or abridges those rights. Similarly, in the case of Akula Mahas versus Federation of Pakistan in 1998, the court held that the independence of the judiciary and the separation of powers are part of the basic structure and cannot be altered by constitutional amendments. If we talk about the current situation, lawyers of Roundtable Conference on Saturday questioned the oft-repeated argument the legislators about the supremacy of Parliament, declaring that it is in fact the Constitution is supreme. Prominent among those who speak at the conference touches sanctity of the Constitution and judicial independence of Pakistan. Hamid Khan said, "It was unfortunate that everyone was doing his own interpretation of the Constitution." He said people calling for a joint general election in the country were incorrect in their interpretation as it was not written in the Constitution. He said all institutions were bound to obey the CSS orders. He said lawyers had a prime responsibility to stand with the Constitution and judiciary. Thank you.
Abdul Fattah, in his conclusion, will address those specific queries. It has been suggested by my learned friends from the other side that when the Constitution is adopted and enacted, providing clear rules of each organ and institution of the state and government, then there should be no question about the supremacy of one institution and the Constitution itself takes the precedence. This argument about pure supremacy of Constitution ignores the glaring fact that Constitution for its major part is a document that discusses and provides the structures and activities that are either political in nature or that take place in the realm of politics. This is the reason that the jurists and scientists have come up with the concept of political constitutionalism, which argues that Constitution should not be made a strict legal document, like ordinary statutes, but there should be some flexibility in it, and political actors acting through the parliament should be given authority to decide such questions through dialogue and politics. The current fiasco of provincial elections in 90 days is a clear manifestation of this theory, when the Supreme Court, after stubbornly insisting upon the conduct of election within a certain time period, finally asked the political parties to resolve the issues with the dialogue. I will leave my worthy opponents with some questions, and I would love to hear their responses on the said questions. Number 1, what answers do you have for the Article 239(5) and 239(6) of the Constitution, which clearly state that there is no limitation on the power of the Parliament to amend the Constitution? Number 2, the theories of basic doctrine, structure and alike concepts are nothing but creation of judiciary. Which provision of the Constitution you think make the Constitution supreme or provide for the basic structure of theory? Number 3, keeping in view the well-documented history of oppression and unconstitutionalism shown by our higher judiciary, why do you still think it is a good idea to argue for the supremacy of the Constitution and in return stand in the favor of supremacy of court? Thank you.
یہ بات بڑی دلچسپ ہے کہ اراکین پارلیمان کی خواہشات کا ڈراوا وہ گروہ دے رہا ہے جو خود ہمیں غیر منتخب اور متنازع ترین ماضی رکھنے والے منصفین کی مرضی اور منشا کے سامنے دھکیل دینا چاہتا ہے۔ میڈم اسپیکر، قانون کی حکمرانی پارلیمانی بالادستی کے تصور کے نہ خلاف ہے نہ اس سے متصادم، بلکہ وہ قانون کہ جس کی آج یہاں بات کی جا رہی ہے، جس کی حکمرانی کے چرچے جو ہے وہ عام کیے جا رہے ہیں، وہ خود اپنی لازمی حیثیت، اپنی سند اور اپنا جواز پارلیمان سے حاصل کرنے کا محتاج ہے۔ میڈم اسپیکر، میں جانتا ہوں کہ ظفر علی شاہ کیس میں ہماری سپریم کورٹ ایک غاصب کو محض قانون سازی تو ایک طرف آئینی ترمیم کی بھی اجازت دے چکی ہے۔ گویا آئین میں پارلیمان کی طاقت ہونے کے باوجود بھی پارلیمان کو بنیادی ڈھانچے کا پابند اور ایک غاصب کو لامحدود اختیارات کا مالک قرار دینا ہماری عدلیہ کی ایک غاصب کو لامحدود اختیارات کا مالک قرار دینا ہماری عدلیہ کی معراج ہے۔ آج یہاں پارلیمانی بالادستی کی مخالفت کرنے والوں کے ترکش میں سپریم کورٹ کے چند غیر آئینی فیصلوں اور خود ساختہ فلسفوں کے علاوہ کچھ بھی نہیں، اور میرے یہ دوست یہ بتانے سے بھی قاصر رہے ہیں کہ آئین کی وہ کون سی شقیں ہیں جو آئین کے بنیادی ڈھانچے کے تصور پر دلالت کرتی ہیں۔ میڈم اسپیکر، عدالتی فیصلوں کے ساتھ ہر لحظہ بدلتے بنیادی ڈھانچے کے اس تصور کے خلاف سب سے بڑی دلیل یہ ہے کہ پارلیمان آئین کی خالق ہے، اور خالق کی گئی ترمیم تمام غیر خالقین کے فلسفوں پر فوقیت رکھتی ہے۔ میں اس بحث کو سمیٹتے ہوئے گزارش کروں گا کہ آئینی بالادستی کے پردے میں جسٹس منیر سے جسٹس ثاقب نثار تک کے اس عدالتی بالادستی کے سفر نے ہمیں وہ زخم دیے ہیں کہ پارلیمانی بالادستی کی مخالفت کرنا ہمارے آئینی شعور پر تو سوال اٹھاتا ہی ہے، ہمارے اجتماعی دانش اور تاریخی استدلال کی صلاحیتوں کو بھی شک کی نظر کر دیتا ہے۔ بہت شکریہ۔
My opponents said right. However, if we take a look to the first Constituent Assembly, it was elected by the people. The first Constituent Assembly was formed by elections held in United India, which was later on separated from Indian Constituent Assembly in 3rd June Plan, and Muslims relied on that Constituent Assembly earlier than 2nd Constituent Assembly was made. The 2nd Constituent Assembly was elected from the existing provincial assemblies and consisted upon 8 members. You are right to the extent that Parliament exercises democracy. The question arises, arises upon democracy, that it really doesn't mean that only parliament is the very thing which can exercise democracy, but also constituent assembly too. Because democracy means rule of majority. We can take the definition of Aristotle. Democracy is the form of government in which the supreme power lies with the citizens as a whole, and they have the right to participate in the decision making. We can take another definition, Nelson Mandela. Democracy is the expression of the will of the people. There is no written anywhere that parliament is the only thing where democratic principles can be exercised upon, but also other means. The Constituent Assembly was a body, not a creation of British Parliament. It is, in my opinion, to be regarded as a body by supra-legal power to discharge the supra-legal function of preparing a constitution of Pakistan. Justice Cornelius said, it was stated from time to time in the course of arguments that the Constituent Assembly derives power to make laws for the domination from the Section 6, Clause 1. But with great respect, it seems to me that the interpretation overlooks the fact that Constituent Assembly was a body, not a creation of the British Parliament. It is, in my opinion, to be regarded as a body created by powers in respect belong to itself inherently by virtue of its being a body representative of the will of the people in relation to their future mode of government. We can say that the Constitution is made by Constituent Assembly, but it really doesn't mean that Parliament made it. It is right to extent it is a part of Parliament, but it really doesn't mean that it is Parliament. Thank you.
I appreciate all the hard work and efforts made by the different team members and their mentors. As per the results compiled by my honorable deputies and verified by me, the group or team B and C, team B mentored by Dr. Yasir Aman Khan and team C mentored by Mr. Ali Ahmed Shah, there is a tie between these two teams, and they both have been marked as the best group by the jury, and accordingly the resolution is neither passed nor dismissed. The resolution is open for further discourse. I thank the honorable mentors, the distinguished speakers, and the respected members of the jury. I bring this session to close. The House is adjourned.